An emergency action was just decided at the United States Supreme Court, concluding a massive, fast-moving constitutional showdown over digital privacy, state powers, and how every single American accesses mobile apps. The case represents a massive battle between Texas and a broad coalition of student advocacy groups and major tech platforms. This entire fight is over Texas Senate Bill 2420, better known as the App Store Accountability Act. This is not just a localized issue. This law mandates a fundamental overhaul on how apps actually function within the state of Texas, and this has ripples that will inevitably actually hit the entire country. The Supreme Court became involved after the Fifth Circuit Court of Appeals stepped in, stayed a lower court injunction, and allowed Texas to begin enforcing this new law. Now, in response, an emergency application was filed to the Supreme Court asking for them to intervene immediately and block this law. Well, we now have the official response from the Supreme Court, so let's break down exactly what the law says, why the courts are completely split on this issue, and the massive constitutional stakes behind what the Supreme Court just did with this emergency order. Now, before we break down what happened in the Supreme Court emergency case and what this means going forward, if you like this type of video and you want to make sure you get this content going forward, make sure you subscribe to the channel and also turn on all notifications to make sure you never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. And right now, if you sign up using the links down below and you use my exclusive code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee. Now, to understand why this case moved with lightning speed to the Supreme Court, we have to look at the severe mechanics that are actually at play with Texas SB 2420. This is not a standard social media restriction. It targets the point of distribution, which is the actual digital storefront itself, where the apps are downloaded onto your phone. Under the text of the App Store Accountability Act, any digital marketplace offering mobile applications to users in the state of Texas must implement a mandatory universal age verification framework. If the system identifies a user as being underage, a sweeping set of restrictions immediately locks down that device. Under the law in this process, these individuals, the underage individuals, are completely barred from downloading any new application, regardless of its content, rating, or educational value, unless a parent is verified and linked to that account. The law explicitly outlaws also blanket consent. A parent cannot simply log in once, sign a waiver, and give the kid permission to use the App Store freely. Instead, the law mandates a process of individualized transaction-by-transaction consent by the parent. Every single app download, update, or in-app purchase requires separate parental consent. Finally, the law places strict limits on how platforms can track, profile, or monetize the data of any user under the age of 18. If an app store fails to comply with these requirements, they face devastating civil penalties and enforcement actions that can be brought against them by the Texas Attorney General's office. Now, of course, this law came with criticisms and there was significant challenges to this law. Critics noted that to safely comply with this law, platforms like Apple and Google would have to force every single individual, including adults in Texas, to upload government identification or biometric data just to prove that they are not a minor. In this case, Texas's main position is built on the traditional police powers of the state to protect minors from harm. Texas argues that the modern digital landscape has fundamentally altered the nature of childhood. So proponents of this law present data showing that unrestricted access to these types of apps in this ecosystem can expose children and underage individuals to the algorithm. It becomes addictive and can potentially cause harm to them in how they develop. Texas argues that SB 2420 is also not a regulation on speech. Instead, Texas argues that this is a regulation of commercial conduct and digital transactions. The state points out that the app stores function as a digital toll booth. They process financial transactions, take cuts of revenue, and execute commercial contracts and do those types of executions when that user clicks download or purchase. Because the Supreme Court historically grants states much broader latitude to regulate commercial transactions and protect consumers, Texas asserts that strict First Amendment scrutiny should not even apply here in this case. Furthermore, Texas argues that this law does not silence youth. Instead, they claim that it empowers parents, gives them back their powers and their parental rights that have been eroded by big tech companies for years. On the other side of the aisle, you have the applicants here, which are the students engaged in advancing Texas, which is the SEAT group, and they're represented by multiple civil liberty groups. Alongside, this lawsuit is also joined by big tech companies that want to fight against this law. Their argument is very clear that SB 2420 is an unconstitutional system of prior restraints in violation of the First Amendment. The applicants state that the mobile applications are not just commercial widgets or physical products. They are the modern equivalent of books, pamphlets, or town squares. They claim apps are how young individuals read news, organize political rallies, practice religion, and also express themselves. These groups argue that the Supreme Court's long-standing precedent firmly establishes that speech does not lose its First Amendment protections simply because it is distributed via a commercial platform or is exchanged for digital currencies. So by forcing every citizen to prove their identity and also their age before accessing this information, the state is creating an electronic gatekeeper. The applicants here point to several critical flaws in this law, one major one being that the law was not narrowly tailored to meet its purpose because the way that the law was written would require everyone to verify who they are, verify their age, and force even adults to have to download that information so that they can just get access to these apps. Now, the procedural history of this case is exactly why this moved so fast on an emergency review to the Supreme Court. When the lawsuit was first filed, a federal district court judge issued a sweeping preliminary injunction blocking this law entirely. The district court agreed heavily with the tech companies and the student advocacy groups, finding that the law was overwhelmingly likely to fail constitutional scrutiny because it was not narrowly tailored to serve the state's goals. The judge blocked this Texas law and blocked them from enforcing any single piece of this law. But Texas immediately appealed up to the Fifth Circuit. And on review, the Fifth Circuit granted an emergency stay of that district court injunction. By staying the injunction, the Fifth Circuit allowed Texas to immediately begin enforcing SB 2420 while the formal appeal is now being argued. This whiplash is what forced the applicants to file for an emergency Supreme Court application. They wanted a vacatur of the stay. They wanted the Supreme Court to get rid of that stay that was issued by the Fifth Circuit. And that really brings us to the showdown that happened on the Supreme Court shadow docket. Now, the shadow docket is the court's method of handling these types of emergency requests outside of the normal year-long merits review process that they traditionally do. Because the Fifth Circuit's actions altered the status quo and allowed a highly contested law to take effect immediately, the High Court was forced to step in on an emergency basis. The Supreme Court has now officially issued their order in regards to that emergency application. The application to vacate the stay, which was presented to Justice Alito and referred to him to the full court, was officially denied. This means that while the broader legal battle continues to play out at the lower court level in the Fifth Circuit, the Supreme Court has chosen not to intervene at this early stage. But make no mistake, while this isn't a final permanent ruling on the constitutionality of this law itself, it is a massive procedural indicator. Dozens of states have passed variations of this law, and the federal circuit courts are completely split really on how these frameworks violate the First Amendment or represent a valid state protection. The Supreme Court's choice to leave the Texas law active for now sets a critical baseline for how these legal battles will likely proceed across the nation. So that is what's currently going on in this emergency Supreme Court case in response to this new Texas law. Let me know your thoughts down in the comment section. Do you agree with this law? Do you believe that Texas is simply trying to protect children and give parental rights back to the parents? Or do you think that this law goes too far, it violates the First Amendment, and these types of issues should essentially be left to the parents and the parents should make their own decisions? Let me know your thoughts and comments down below in the comment section. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.